Ladies and gentlemen, welcome with you, Professor Olaniwaju Adesola Olodede. Thank you very much. We also have the faculty, our very revered professor, the learned professor, the director of Ecoside Nigeria, and a venerable of the Church of Nigeria Anglican Communion, our old very professor, Venerable Reverend Eos Okwesi. We also have another distinguished professor. He's well known in the field of sport law, and he is also the chairperson of the planning committee of today's event. Ladies and gentlemen, please welcome with me Professor Ayodeji Peter Agbokibi. And today, we are here today to listen to somebody who is well known in the field of legal practice in Nigeria, a distinguished advocates, who very soon we shall be hearing his lectures. But before then, let me warmly welcome, on behalf of the Dean of the Faculty of Law, Mr. Norrison, QUAKERS, Senior Advocate from Nigeria. As you would observe, the lecture of today revolves around arbitration. He is a fellow of the Chartered Institute of Arbitrators in Nigeria. Let's give him a round of applause again. Also, we are indeed very blessed that he decided not to come alone, as you must have been told quite often and often, that behind every successful man is a woman. We have with us Mrs. QUAKERS. Can we give her a round of applause? Thank you very much, ma'am, for coming. We have members of the university community here at large. We have the dean of the postgraduate school, Professor Ibinabo. He just stepped out. We have Dr. Ubejita from Faculty of Mass Communication. We have Dr. Fitema from Faculty of Mass Communication. We have Dr. Bamidele from Faculty of Mass Communication. We have Venerable Dr. Efuwole. You are most welcome, sir. We have members of the University Press, University Radio. We thank you for being here. And we have our amazing students. Mr. Vice Chancellor, I'm sure the team will make reference to the fact that at the last concluded outing at Nigerian Law School, our students had 4 first class. And that is, thank you, that is to show the quality of the students that we have here. Thank you very much. I have the pleasure to invite the Dean of the Faculty for his opening address. A round of applause for the Dean, please.
the Vice Chancellor, ably represented by the Deputy Vice Chancellor, or the Vice Chancellor of Edways, Professor Timothy Abiodun Adebayo, ably represented by the Deputy Vice Chancellor, Professor Muyiwa Okuola. Our guest lecturer, Mr. Norris QUAKERS, Senior Advocate of Nigeria, and his amiable spouse, Mrs. QUAKERS, thanks for being with us today. Distinguished members of the university community, the university chaplain, distinguished deans present, professors, and other academics who are here present, and our visitors from outside. We welcome you all. Not to forget our, I don't know whether I should call them the landlords or the tenants, our students in the Faculty of Law, who I'm sure in course of time, some of you will be invited to do exactly what Mr. QUAKERS will be doing here today at some institution in the near future. Distinguished ladies and gentlemen, I must not forget a very distinguished team from Performing Arts Department, led by their lecturer, Mrs. Sorry, madam, I just left me, but I know you very well. Thank you very much, and God bless you. The purpose of having a faculty lecture is to allow our students to benefit from the knowledge and experience of eminent members of the legal profession who may not necessarily be in the academic sector, but who are erudite, have made contributions, and still continue to make contributions, and whom we know we will benefit from when they interact with us. You are very lucky today to have one of such members of the profession with you in Mr. Norris QUAKERS, who has rather, I would say, unusually sent in his presentation well ahead of time, which I must say is very commendable. Thank you very much, sir, for that. And which is a topic that is present and future in outlook. That is alternative dispute resolution. Now, you are very lucky because you are not only being told about litigation, which was what it was in my own time. We went to university to learn the grade letter law, and when we got to the law school, we were taught litigation. In fact, corporate practice was at its infancy. We learned, I really didn't understand what corporate practice meant until, well, after becoming a lawyer, because we were only looking at litigation, and that was what made the profession at that time. But the world has changed, and it's still changing. And we know today that litigation does not solve all the problems. And that is why I say you are lucky, because you are going to listen to a practitioner that has practiced in the field and can give you a lot more than what you will find even in textbooks. So I will advise you all to listen very well. Fortunately, you have been given copies of the lecture, and to also keep this lecture because you may need it in the future. Now, don't think I'm joking about it. I'm serious. And in fact, form part of your library. You should form part of the library when you become legal practitioners. And if you feel that you will benefit from it in court or at any other professional outing, please take it along with you as a book of reference. I have no doubt that at the end of the lecture, you will have gained a lot more than you know as at now. And even for those of you who have had some exposure to alternative dispute resolution at one level or the other, you will still gain much more after listening to a seasoned practitioner in the field talk to you about what it entails. So please listen carefully. If you want to make your notes, don't hesitate to make your notes. And if you have any questions you want to ask, please note those questions. And at the end of the lecture, you'll be given the opportunity of having your intervention. I believe you will benefit from it. Now, let me also thank Mr. QUAKERS for making the trip all the way from Lagos. You say Lagosians don't know the way. Instead of taking the good road from Ibadan to Oyo, he took, he took the express, contending with trailers and tankers. Now he knows that there is a backyard road he passed that is a bit safer and certainly better because you always see in communities, you can't drive 3-4 kilometers without getting to a community. So I'm sure we'll enjoy the ride back to Lagos. So I will counsel you to listen and enjoy the lecture. Thank you very much.
Thank you very much. I also have the honor to introduce the academic staff of this great faculty, this prestigious faculty. And apart from the learned professors that I have mentioned, we have with us today Dr. Tope Oshijobi. We also have with us Dr. Dari Ayinde. We have with us Dr. Ilisomi. We are hoping that after his sabbatical, he will stay with us. We have Mr. Sunday Ayew. Mr. Demola Sunday. Also, we have Ms. Juliet Abba. And we have a fantastic faculty officer, Mrs. Olaiton. Among the categories of students, we have an LLM students here. We have His Worship Aderemi A. Adebi. Thank you very much. This is the point where we will be hearing from the Vice Chancellor. Can we stand up while we clap as Vice Chancellor now?
Can we please be seated? In the name of God the Father, God the Son, and God the Holy Spirit, I have the mandate of our Father, a progressive individual, a very tireless man that God has brought to this university at the right time. Professor of Agriculture, not only in theoretical terms, but in practical terms. A peace advocate of growth. That is our dear Vice Chancellor, Professor Timothy Abiodun Adebayo, Fellow of the Chartered Institute of Agriculture of Nigeria, and Fellow of the Horticultural Society of Nigeria, to represent him at this very important event. Other principal officers of the university are not here. He himself is unavoidably absent. That is why he has asked me to stand in for him, because right now he is busy presiding over an interview that he must not bet preside over with other principal officers of the university. That's the reason why he's not here, and other principal officers who are his able supporters. And for me to be here, that means he has given me his blessings to represent him. And he has said I should not fail to recognize the presence of our distinguished Dean of the Faculty of Law, a very eminent professor of law, senior advocate of Nigeria, Professor Olanrewaju Olodeko. He said I should thank you for organizing this lecture and for making sure that what Agricultural University is known for is being established and is being promoted, is being shouted to the rooftops by the faculty under the watch. And that he is very, very happy that by the special grace of God, by the time you know distant time, you will be leaving the law program of our distinguished university is enjoying full accreditation of the National Universities Commission. Our law program now, I expect you students, because perhaps you know that on behalf of the VC, I will scold you. That is why you are not clapping. You have to clap. The law program of this university, by the special grace of God, has been fully accredited by the National University Commission. The meaning of that is that in the next 5 years, NUC does not have any business visiting us as a university in respect of our law program. We can admit, you get out, you go to the law school, you can. With every pride, with everything that God has given you, with every sense of belonging, with every sense of championing a cause that is good, that we are known for as a university. Tell everybody that by the special grace of God, I am a graduate of law for the Ibinabo University that is fully accredited by the National Universities Commission. The Vice Chancellor said I should come today's guest lecturer, the senior advocate of Nigeria. That is our revered and learned, I don't know how to use that one. Will I say, because I'm not learned, I know, but well, it's unfortunate. Well, even PhD, and you say I'm not learned. Now, wow, God will help all of us. No, just break it. Our distinguished SAN, we thank you very much for finding time, for making up time to honor our invitation. God will honor you. The Vice Chancellor said I should thank you very spiritedly, that he knows that for you to have left your duty post to be here, it means you have very strong belief in us. It means you are a very good partner with us, and it means you believe in our ideals, and that we don't take that for granted. I also thank the amiable wife of our guest lecturer for the support and for coming with him to honor us in this regard. May God bless you. I thank the leadership, part of the leadership of the Faculty of Law, organizers of this event, who have stood firmly behind the dean to make sure that today's event is not only a never to be forgotten one, but are never to be remembered one as well. Thank you very much. Members of Senate of the university, some of you who are here, I recognize you on behalf of the Vice Chancellor. Thank you very much for gracing this occasion. I must also single out one of our very good neighbors, one of our own very good associates, one of our own very good friends who believe in what we do here, and who has been lending our whole very good hands to us to make sure that everything is well, especially as having to do with our surveying and geoinformatics program. That is the rector of the Federal School of Surveying, here present, Sophia Dr. Lupe Nilola Olayinka Dosu. On behalf of our Vice Chancellor, would you please, with due respect, leave that place and please take that seat over there, that seat over there. Please, with due respect, please. You are welcome. You are welcome. You are welcome. You are welcome. Thank you very much, everybody. The chaplaincy, thank you very much. Well, Vice Chancellor said I should not fail to hint at the fact that Adekoya University, as he has been saying, is an institution to the glory of God, that he will live very soon better than the way he met it. And that is how every good administrator, a successful administrator talks. He is also, already praying for whomsoever that is going to take the mantle of leadership of this university from him. So that by the time the person will also leave, the fold of this university, let's say in the year 2030, that person will also leave it, the way better than he will, meet it by October 1, 2025. He has said that again this morning when I was coming, because of the fact that he remains excited. He was beaming with blessedness and peace and basking in the euphoria of God's glory and faithfulness upon us as a university. That we don't just profess that we are a university through documentations, through books, by writing things down. We try as much as possible by the special grace of God to operate as a university that keeps established academic traditions. One of the established and, possibly referenced academic traditions that a university that is growing, that is ranking among the best, is known for is a public lecture such as this. And that is the reason why the university management is happy with the Faculty of Law for doing that which is good. It offers a forum for turn and gown, interaction. It offers a forum for peer review. It gives a forum for putting into perspective contemporary issues, topical matters of national and international importance. And one, of such instance is the topic that we are said to be treated with delicacy in respect of today, alternative dispute resolution. It's a topic that is both timely and timeless. It is an evergreen because it reminds us as a university of African approaches to conflict resolution. We are not talking just about formalized conflict resolution by the means of litigation going to court. We are going back to the basics, how our forefathers were resolving conflict amicably, 50-50. When you win, you are ready to win some part, I'm ready to lose some part. You are ready to lose some part, you are ready to win some part. So that at the end of the day, peace will reign, not graveyard peace. Mr. Dean, sir, distinguished SAN, On behalf of the Vice Chancellor, we thank you for this, important topic. Thank you for the, contemporaneous, significance of this topic. And dear students, as our dean has told you, write down so many things. Take your jottings, don't just listen. I will not scold you again, I will just advise you. It is not good for this type of lecture to be organized, to be delivered by a senior advocate of Nigeria. And this place is, we still have empty seats. We still have empty seats. I will tell, because when I went back to the visit to say the students were not there, he was angry. He was furious. He said, I would discipline everybody who is a student in the Faculty of Law. Then now I will go back and beg. I will say, my Oga, you are a father. Please pardon them. They will not do that again. Will you do that again? You are saying yes. Let me catch you. Say yes. I know somebody is saying yes because yes, he wants me to identify him or her. The person meant no. At least you have done well by being here, by sitting down. What about those who are not here? May God forgive them. You can imagine what they will miss. God will be with you. The day that what will benefit you will be said, you will not be found wanting. You will not be found absent. Well, on behalf of our Vice Chancellor, once again, we thank you today. We thank our guest lecturer for being around. Well, let me say this as a media person and as a newsman for the sake of clarity, validity, and accuracy. I thank my very good brother, friend, and colleague when he was trying to introduce me. Well, I'm yet to become a fellow of the Nigerian Academy of Letters. I'm a member, just a member for now. Maybe he has prophesied. So, maybe he has prophesied. And I want to say that God will let your prophecy translate to reality. Therefore now, I'm a member of the Nigerian Academy of Letters. I am yet to become a fellow of the Academy. On behalf of our Vice Chancellor, once again, this 2025 public lecture of the Faculty of Law of this great university is declared open in the name of the Father, in the name of God the Father, God the Son, and God the Holy Spirit. Thank you very much.
We will thank the Vice Chancellor for that opening remarks, and we thank dear Deputy Vice Chancellor, the soon to become Fellow of the Nigerian Academy of Letters, for that presentation, sir. Let me also recognize the representative of the Director of Research and Linkages, Dr. Olabi Wanimu, who has sent Mr. Samson Oyedamola to represent her. Thank you very much. We thank the webmaster who is ensuring that this event is being streamed live across all social media platforms of the university. Mr. Vice Chancellor, sir, distinguished ladies and gentlemen, we are now at the point to listen to why we are here. And it gives me great pleasure to invite to this part of the podium Dr. Toko Oshikiwu to read the citation of the guest lecturer. May I also respectfully ask that you please stand while Dr. Oshikiwu will read the citation. Can we give Dr. Oshikiwu a round of applause?
Good afternoon, everyone. With me is the citation of our very distinguished guest lecturer today, Mr. Norrison, QUAKERS SAN. Mr. Norrison, QUAKERS SAN is an astute legal practitioner and one of the leading progressive voices in Nigeria. Recognized as one of the top 100 lawyers in Nigeria, he is a highly respected public commentator, renowned analyst, and prolific writer. I expect a round of applause for that. Now listen to this. He also consults for foreign courts on matters related to the Nigerian legal system and other critical legal issues. He obtained his Bachelor of Laws from Lagos State University in 1990 and subsequently earned his Barrister at Law qualification from the Nigerian Law School in 1991. In recognition of his outstanding contribution to the legal profession, he was conferred with the prestigious rank of Senior Advocate of Nigeria in 2011, and equivalent title of a King Counsel in the United Kingdom. Mr. QUAKERS is the fellow of the Chartered Institute of Freight Forwarders of Nigeria and the Chartered Institute of Arbitration. He is also a member of the Administration of Criminal Justice Review Committee and the National Working Committee for the Review of the Law of Evidence and Nigerian Evidence Act, chaired by Honorable Justice SMA Belgore, GCOA, former Chief Justice of Nigeria. Additionally, he serves as a resource team at the Chartered Institute of Directors, and he is currently the president of the Lagos State University Alumni Association. His expertise spans various areas of legal practice, including general litigation, covering civil, criminal, human rights, and admiralty cases. He has a special interest in maritime dispute resolution and is actively involved in public interest litigation, environmental and urban planning law, arbitration, and of course the topic of discussion for today, alternative dispute resolution. His legal practice also extends to commercial law, banking and finance, labor and employment law, investigative research, legal drafting, institutional reform and development, legislative advocacy, public affairs analysis, justice sector reform, regulatory review, and he is renowned for handling several martial court cases of constitutional importance. As a thought leader in the legal field, he has authored several publications, including Law of Evidence Reform, Legal Enforcement and Institutional Reform to Combat Corruption. Mr. QUAKERS is currently the principal partner of Jerry and Grace Attorney. Kindly give a warm welcome to our distinguished lecturer of the day, Mr. Norrison, Ibinabo, SAS.
Thank you so very much. There's this song that I recall a while back. So some of you will know that song. Now, before I go into presenting the paper that I have prepared for all of us to benefit from, I will try as much as I can to make the lecture a bit more lively and a bit more interactive, because your future is also anchored on some of the things that we're going to talk about. Yesterday when I came in, I said that the law faculty is a breeding ground for lawyers. Somebody sent something to me on Facebook and also on WhatsApp about the classroom. All of you are seated now in this classroom. Amongst you, one or two might end up being in government. One or two might end up being in the National Assembly, either at the federal level or at the state level. Some of you end up being lecturers. Some of you will end up being entrepreneurs. But the fact is, whenever the roll call or success is made, don't be found wanting. And that starts by you first building an ambition for yourself and working towards it. So as I go into the lecture, I must first and foremost recognize the Vice Chancellor of this great university in the person of Professor Timothy Abiodun Adebayo, who I have been introduced to this morning. Praise God Almighty. Now, why did I say praise God Almighty? Because this is a faith-based school. So you bear with me if occasionally it is spiced with things like that. All right? Now, he's represented by no other person than the Deputy Vice Chancellor in the person of Professor Benjamin O. Okuola. You can give him a round of applause. And I thank the Deputy Vice Chancellor. He's also very busy. When we went to see the Vice Chancellor, they actually in a meeting, but he was seconded to come and declare the meeting open. Now, I have a man I can describe as one of our fathers in the legal profession. And why am I describing him as one of our fathers in the legal profession? It is not easy to be in charge of the Nigerian law school. And if I were you, tap as much as you can tap from him, take as much as you can take from him. It is very difficult to be in charge of the Nigerian law school. He left the Nigerian law school and came here as the dean of the faculty. I have the great privilege of recognizing him once again, Professor Olariwaju Onodepo, SAN. I do not know why your rank is also not put on the program. He's indeed a senior. You know what it means to train lawyers who become senior advocates and professors of law, and you will not be conferred with the rank and not also be recognized. So I recognize him. I also recognize all the academic staff that are here. Dr. Temitope Oshutogun, Professor Gaius E. Okwesezi. I hope I'm right with the pronunciation of your name, sir. Okwesezi. Okay, all right, thank you so much. I don't want to murder his name so that I'm not accused of that. There's also Venerable Alban Iwuzie. Thank you so very much. And to other distinguished members of the public and also to my colleagues, the budding lawyers in the law faculty. It gives me great pleasure to be here to present my thoughts on the topic resolving commercial disputes in a globalized Nigeria, the role of arbitration and alternative dispute resolution in private law. Now, before I delve into the topic, let me say one or two things about myself that you will also appreciate. At some point in my life, I went to one of the top secondary schools in Lagos, St. Philip's College, and I left the school with a record. I was one of the most notorious boys of the school at some point where I was recommended for psychiatric evaluation because I was rascally and very notorious. It got to a point in my life where I said I wasn't going to school any longer, and I embraced the martial arts. And I did martial arts up to black belt level, and I earned a 4th dan black belt degree. All right? I was very unserious. But it got to a point in my life where I had to read anything and everything in print. Now, I grew up in a highbrow neighborhood, and those of you who are from Lagos will know Surrey very well. I lived off Adeno Ogusoya, but middle class environment. But there was something we used to do in the neighborhood. We gave ourselves challenges by arguing or being involved in intellectual discourse. But because I wasn't in school, anytime we argue, there's this neighbor of mine who would not be saying to me, after all, you're not in the university. After all, you're not in the university. I said, okay, all right. Because he was being intimidated by the fact that many of us read anything and everything in print. Because I didn't want to appear to be a neophyte. I didn't want to appear to be ignorant. I acquired knowledge. I acquired information. And I was reading anything that crossed my path, anything that crossed my way, any book at all. Now, along the line, I went into university. All right? And then I was doing University of just my mom put pressure that I should come down to Lagos. So I ended up in Lagos State University. I was among the third set of the university, the third set. All right? Long and short, I graduated. And guess what? I went to work in a law firm. Some of you will know him. And I will use this to also encourage you, budding lawyers. Don't be in a hurry to go and set up your practice. You need to go for pupillage. You need to go for training. You need to go for learning. I worked under one human rights activist, Olisagbakoba SEN, for 18 years, back to back. I had no social life. All I was just doing was just going to court. All right? I love litigation so much, that somebody once described me as a court rat. I was going in and out of courtrooms. Before I applied for sale, 5 years post-call, I had done all the cases to qualify me to become a senior video, but before you can apply, you must be 10. So my first application was put in on the dot of 10. Why did I do so? I wanted to match Latifa Gbemi's record, the current Attorney General of the Federation, who became a senior advocate on the dot of 10. So I said, I want to become a senior advocate on the dot of 10. But it never happened on the dot of 10. Eventually happened in 2011, 10 years after. But I never give up. Back to back, pursuing my dream, pursuing my goal. And today, to the glory of God Almighty, I'm also turning the week now. All right? Now, what are we to discuss this morning? The topic has been presented to you. One key component in relation to this is that there will always be dispute in every human society. Because of course, there will always be misunderstanding. There will always be conflict. There will always be disagreement. Whenever this happens, you must ensure that you deploy some mechanism for the resolution of those disputes. Now, earlier I said I started with litigation, and I'm happy that you did also refer to it. When you go to law school, at that time, what many were being taught was about litigation, procedure, practice, and all of that. Nobody touched the issue of arbitration as another method or mechanism for resolving disputes. Now, dispute resolution has several components. One of it is litigation. The other is arbitration. There is also conciliation and many others. Some people describe another one as negotiation, where you can sit down and talk. Now, the key thing is, in all the other components, you will not find a judge who seeks to determine it. Why will you not find a judge? Because parties are being encouraged to talk. So you must sit and engage yourself in discussion. Once it is identified that there is indeed a conflict, so what's the next thing that you do? You sit down to talk. And I'll give you a scenario as we go into this. Two friends went into an agreement, went into a contract, and reduced all of that. I know you have been taught here. Reduced the agreement into writing, agreed to terms and conditionalities, and they both signed off. Friends, very good friends. And along the line, friend B breached the contract. And friend A was so upset, he now approached a lawyer that he was going to sue that his friend. Now, if you're going to deploy alternative dispute resolution, it must be contained in your contract of engagement. So that clause was not in the agreement. So he told a friend of his, and the friend said, why sue this guy? Why don't you guys sit down and discuss it? There's obviously a dispute, and this dispute is something that can be discussed. Why go to court to incur more expenses when you can discuss and agree as friends and then sign off? So what did he now do? He now appointed himself as an intermediary for both parties with a view to ensuring that the parties are given the opportunity to talk. And then eventually, they looked at the agreement, and the agreement had the clause there that before you get so upset of seeking redress by constitutional means, you must interface. You must write calling for a meeting. You must write about your grievance. And he hadn't done all of that. There's something called condition precedent before you can even approach the court if it becomes necessary. Now, on account of the intervention of this friend, the issue was eventually resolved. Arbitration is as old as human history. It is nothing new. Permit me to also refer to Exodus 18 from verse 14 to 16. Moses held court with the Israelites based on dispute he had observed. He was counseling them and discussing with them until when his father-in-law came around and saw what he was doing and realized that it was enormous. So you see arbitration there. Arbitration is to give you an opportunity to express yourself to the other side and then to also hear you. So the foundation of arbitration is as old as human history. You heard when the DBC was also saying it. In traditional African society, people never took their matters to court. They tried to resolve their matters as much as possible. Now, what gave birth to arbitration that we're talking about and mediation? As a maritime lawyer, one of the things that we realized that many years ago, if you go back in time, you realize arbitration started taking root in this country from the year maybe about 2000. In the 90s, there was no issue about arbitration. But those foreign companies that were coming to Nigeria to do business with Nigerians eventually realized that Nigerians were taking advantage of them, particularly in relation to maritime trade, maritime practice, admiralty practice. What was it? All bill of lading and charter party agreements didn't have arbitration clause at that time. So Nigerian lawyers will rush to court, obtain an ex parte order of injunction, what we describe in maritime practice as ship arrest, and arrest the vessel for the purpose of extorting or extracting money from the owners of the vessel. Now, they are better organized in terms of redressing claims than we are in this part of the world. Now, they have clubs in England and Wales called P&I clubs, Protection and Indemnity Club. Is a club of owners coming together to sign up and seek their rights to a body. And it is the responsibility of the body to ensure that it rises to protect all its members when issues of dispute arise. They suddenly realized that Nigerian lawyers were always rushing to court through their clients to stop and ensure that these vessels are compelled to pay money. When those people now realize it, what did they now do? They now inserted in the various agreements what is today described as the alternative dispute resolution clause. That no matter what you do, you can't go to court first. You have to seek an alternative dispute resolution because they didn't have confidence in the Nigerian judiciary. And it's still happening till today. Now, it's so bad now that even dispute resolution that ought to have been in the local environment, I think, Prof, you confirm that too, that is also in the local environment. Arbitration must be held either in a local institution. You have the Lagos Court of International Arbitration, you have the Regional Center for it, and so many others. Now, they don't even do it in Nigeria. Where do they go to? They do it in England because they're sure of what the outcome will be. Now, that takes me to the challenges that confront us as arbitrators. All other things we have touched, but I want to go straight into the challenges that confront us. Every agreement, as far as our legal system is concerned, must have the clause for alternative dispute resolution. Now, what are those challenges? We know about the role of arbitration, which I have just touched. The key features of arbitration, just bear with me, let me quickly go there because of time constraint. What are those key things that challenge us as a people in relation to arbitration or ADR? One of it is our attitudinal disposition to strengthening or obeying our terms in contracts that we sign. You know, this is one part where many of us don't keep faith with contracts. We only look for ways to circumvent because as a people we're not wired to sustain and maintain rules and regulations. Even constitutional provisions have been circumvented as a people. Therefore, in order for us to ensure that we do not circumvent all of these clauses in relation to alternative dispute resolution, we must ensure that we're so disciplined to ensure that these things stand. Okay? Why are we like that? We believe in cutting corners. We believe in circumventing rules and regulations. So when we go into contract, we don't go into contract with a view of ensuring that we adhere strictly to this. The second part again is on enforceability of those contracts. Sorry, it appears that something got into my throat. You don't mind my drinking water? Please, just a minute. Thank you so much. Something got into my throat while I was still addressing you. I don't know whether it was a fly while I was still talking. Enforceability of arbitral awards also in Nigeria is also a problem. Now, whenever an award is made by an arbitral tribunal or panel, it must also be enforced. How do you enforce it? You have to now take it to court. The same court that will not be involved in arbitral proceedings. In order to carry out an arbitral award, you have to now go to court for the court to now adopt it as its judgment. And once a court makes a pronouncement on an award, it becomes binding and enforceable. It means you cannot wriggle out of it. Now, you have instances when arbitral awards are actually being set aside. Why is that so? Because when the court looks at certain things, a particular example, for instance, is if the court looks at the composition of the panel, that the panel is not wired to guarantee neutrality, or the panel, somebody in the panel is now accused of some influence or financial inducement, and this is a fact that can be placed before the court, the arbitral award can be set aside. Or a situation where the tribunal sits over a matter that it does not have jurisdiction to sit over, and then the panel now makes an award, that can also be set aside. And so it's also a common thing here when arbitral panels, knowing that they lack jurisdiction to hear a subject matter, goes ahead and sits and presides over and makes pronouncement. Once it is taken to a court, it will then be set aside. A particular example, for instance, I know some of us are aware of this. The P&ID case. How many of us are aware of that case? The P&ID case that Nigeria got involved in. How many of you are aware? Only the lecturers. Students, please, I beg you, like I said about myself, read anything and everything in print. You're being prepared for the larger society. Nigeria, if not for the intervention of the last government, Nigeria would have lost so much, billions of dollars. The country would have been bankrupt, and it was an arbitral proceeding. The country would have been bankrupt if that pronouncement had been allowed to stand. It was a group of people coming together to sell the country. But because the English judge saw a lot of things that were shortcomings, they were able to reverse the award that had been given against the federal government of Nigeria. Now, but you had a local court that had given pass mark to the transaction. But the federal government felt embarrassed and decided to pursue it all the way. And finally, the award was set aside. So it is important for us to also know that arbitral awards can be set aside when you now discover that the process by which the award was made is questionable. We have a very strong legal system. The Mediation Act of 2023 is apt and is so clear in terms of its provisions and the things that must be looked out for when a panel is sitting before the panel can make an award. The Mediation Act defines all of those things that must be looked at All of those things that must be in place before an award is made. Now, at paragraph 5.4 of the note, you will see where we refer to case analysis, instances of successful and unsuccessful enforcement of arbitral awards. And I said here that the practical implementation of the legal framework governing the enforcement of arbitral awards in Nigeria can be seen in various case laws, instances. Some cases demonstrate the smooth enforcement of arbitral awards, while others highlight the challenges involved. An example was given of the enforcement in the case of Sani against PFS Nigeria Limited, a case in which the Nigerian courts enforced an international arbitral award against the Nigerian parties. Despite the fact that the award was made in a foreign jurisdiction, the court recognized the award under the New York Convention and granted it the same status as a local judgment, allowing the claimant to execute the award in Nigeria. In other words, no award can be enforced except the Nigerian court admits it and makes it its own judgment and makes a pronouncement. Now, when an award is made in a foreign jurisdiction, and there's a particular case that readily comes to mind, but because I know the parties, I'm not going to cite it here, but I'll just give you the facts. A Nigerian entrepreneur entered into a contract with a foreign company in the United Kingdom, and the matter was fixed for a particular day, and in that system, 9 is 9. He was expected to be in court, but because he's a Nigerian businessman, he went to court very late. He saw his lawyer outside, and his lawyer said to him that the judgment has been delivered, and that it was been delivered against him. Now, in that case, a Mareva order of injunction worldwide was obtained against him, freezing all his accounts all over the world, limiting him from having access. Shortly after, on account of this pronouncement, he died because he had no access to funds. Why? Because he was not there when his matter was called. And there's a limit to which the lawyer can go, or the things that the lawyer can say. Arbitral proceedings entails parties. So party A presented his own position. Party B was unable to present his own position because he wasn't there. And the judgment was now given against him. And he lost everything he had worked for. But guess what? One was enforced in the United Kingdom. They brought the award in the United Kingdom to Nigeria to enforce it, and they registered it with the High Court of Lagos State, and that became the judgment of the High Court of Lagos State, and it was accordingly enforced. So all his assets in Nigeria, on account of the foreign pronouncement, were also taken from him because of this same attitude that, we have this general attitude, court ceased at 9 o'clock, or just like events, we know ourselves, we won't be there until maybe around 10 o'clock. That's where they come to cease. And unfortunately for him, he got there and he got a shocker of his life. I was once invited to a court in the United Kingdom, and they had influence and understanding. And we're wondering why this is so. In other words, he's saying, without saying it in plain terms, that our judgments are compromised and our judgments do not appeal to logic and common sense. And we're all living Nigerians, and to a large extent, some of these things we can also confirm. The role of ADR, in cross-border dispute, particularly in the context of international trade, as the global economy continues to expand, the number of commercial disputes involving parties from different jurisdictions is likely to grow. ADR, and especially arbitration, provides a neutral platform for resolving these disputes, ensuring that parties can avoid potential biases of foreign court system. I said to a client of mine, you cannot have a successful arbitral hearing in England against an English company or an English subject. Why is that so? Because in their system, the number of things that they are taking into cognizance. And in our system, most of these things we do not consider. And like I said, if you are to do a letter to register your disagreement, and the agreement says within 21 days of your observance of the grievance, you must do your letter and you must put it forward to the other party. What do we do here? Oftentimes, agreements are signed without looking at those fine details. We sign agreements that we don't even study. How many of us remember that the immediate past Minister of Transport, in an agreement that was signed with China, didn't read a clause that almost appeared as if all the assets of Nigeria had been ceded to the Chinese company? He didn't know. And when it was taken, he said, no, it cannot happen. But you signed it. Sometimes we also do not involve legal experts. Now, there's a difference between those who draft legal documents and just common lawyers. There are clauses that we look out for. When you become a draftsman, there are certain clauses that you must observe in an agreement. So oftentimes you see them, they don't even bother to read this thing, they just sign for comfort and for convenience. And then at the end of the day, they become short-changed. In conclusion, globalization has significantly impacted the nature and volume of commercial dispute, creating a need for more effective dispute resolution mechanism. On the other hand, there have been instances where courts have declined to enforce arbitral awards. A notable case is the Nigerian National Petroleum Corporation against Stolt Nelson, in which the Nigerian Supreme Court set aside an arbitral award on the grounds of public policy. So, arbitration can be set aside on the grounds of public policy, asserting that the award violated Nigerian law. This case illustrates the challenges that can arise when courts interpret public policy expansively, potentially undermining the enforceability of arbitral awards in Nigeria. Moreover, in Shell Petroleum Development Company against International Drilling Company, the Nigerian courts initially resisted enforcing an arbitral award on the grounds of procedural defects in the arbitration process. The case exemplifies how technical and procedural issues can complicate the enforcement process, even in instances where the substantive award is sound. These cases reflect the mixed experiences in the enforcement of arbitral awards in Nigeria. While there have been positive instances where Nigerian courts have faithfully executed arbitral decisions, there is also a notable risk of judicial interference, particularly when courts invoke public policy as a basis for refusing enforcement. So you can see why foreign courts don't really have as much confidence in our system as we expect them to have. Practical challenges in accessing ADR mechanism in Nigeria. While arbitration and other ADR mechanisms have grown in prominence in Nigeria, several practical challenges hinder their effective use. These challenges span legal, institutional, and societal barriers which prevent many businesses and individuals from fully leveraging ADR mechanisms to resolve disputes. Addressing these issues is crucial for fostering a more accessible and efficient ADR landscape in our country. Barriers to accessing ADR services in Nigeria includes, but it's not limited to, the aspect of robust legal framework that encourages and facilitates the use of ADR across various sectors. While the Arbitration and Mediation Act 2023 provides a modern legal framework for ADR in Nigeria, the overall legal environment can still be difficult for many to navigate. For instance, there is insufficient implementation and enforcement of ADR laws at the grassroots level. Many legal professionals and business remain unfamiliar with the full scope of ADR provision, particularly in local and rural areas. How do you tell the farmer in his farm, right, when a breach occurs to supply that he has made, that he does not need to go to court, that he can actually resolve this issue by just engaging the other side for a dialogue, for some discussion? We live in a litigious society where people prefer to go to court. Some years ago, we had a client who could sue anybody and anything in sight. He enjoyed litigation so much. His neighbor had a tree that encroached on his own land. He came to us that he wanted to sue his neighbor for nuisance. Somebody came to press his bell when he was resting. He accosted the person, I didn't invite you. Why will you come and press my bell? That you came, that he encroached on his privacy and said he wanted to go to court. So he was one man who enjoyed going to court. Now, the question oftentimes is, in our legal system, even when you have a judgment, how then do you enforce it? You have cases that have lingered for years. Today, as I speak, Supreme Court is still dealing with matters of 2021, if my memory is not failing me. And we're already in 2025. Now, when will your case be called up? On the average, an assessment has been done. Cases linger for as long as 10, 20 years. From, if a case will move from the High Court to Court of Appeal, then to Supreme Court, you're looking at 20 years. A young man who used to visit his father when the father was practicing as a lawyer, eventually became a lawyer and was working in his father's firm and saw the file that he knew his father was handling and said to his father, this is a 1976 case. Daddy, you mean this file is still in here? He said, yes.
He said, "But why don't you rush to finish it?" He said, "If I finish it, how will I pay your school fees?" So you can see sometimes why cases linger is because of the financial consideration. And I will say this, arbitration is also now being abused to a point where people are no longer having confidence in arbitration. Why? Whenever you're driven by the desire to making money, other than to offer service, other than to resolve disputes amicably with less friction, you're going to run into problems. And that's why we're where we are. Whatever we do, we have messed up arbitration as Nigerian lawyers because we have introduced other things into it. Same thing with litigation. We're raised to understand, as Professor Nodeko is, if he becomes a judge, I must distance myself from him. I don't have to go to his house any longer. I don't have to invite him to parties. Why? I must respect his office. And the reason why that is so, and I don't have any of know this, the definition, for instance, of adultery in our legal system is presumptive. That when two consenting adults come out of an exclusive or excluded place, there's a presumption that adultery has taken place. So it is a presumption, or you must now report it. If I come out of somewhere, like now I'm staying in a hotel, and I come out of the room with someone who is not my wife, the first question anybody will say is, something was, what's the mindset? Something must have happened. That's why judges are encouraged to distance themselves from the larger society. And that's why arbitral panels are now being advised that, look, stay clear from the parties that are before you. Don't attend their parties, don't attend their functions, don't collect gifts from them. But here is a different thing. You see judges at parties dancing. You see judges at nightclubs enjoying themselves. All right? Yes, they are human beings, no doubt. But guess what? Once you take that oath of office, you must distance yourself. And then you as a practitioner, you must also avoid not interfacing with them to put them in a position where they're compromised. It takes two to tango. We accuse the bench today of corruption. But who are those corrupting them? Lawyers. Who have access to them. All right? So it is important that we also talk to ourselves. Institutionally, there is still limited access to ADR services in certain parts of the country. While there are institutions like the Nigerian Arbitration and Mediation Center, NAM, and the Lagos Court of Arbitration, SCA, that support ADR, their services are often concentrated in cities like Lagos and Abuja, leaving out smaller regions and rural cases. I have even gone a step further by saying the reason why this is so is because we have governors who are also not engaging, who are also not prepared to also invest in IGR. And if we continue like this, a time will come, Lagos will be so choked. Even right now, Lagos is choked. How come a lot of people will prefer to go to Lagos to do their business than any other place in the world or any other place in Nigeria? The reason for that is because the governors who have been in Lagos are commercially oriented and commercially minded. And arbitration is an offshoot of commercial engagement, international trade. Foreigners will rather come to Lagos where they see things happen than to go to anywhere else. So there are only 3 places right now that one can say arbitration is actually thriving: Abuja, Lagos, and Port Harcourt. Why? Because of commercial activities. In any other place, nobody would like to use the system. All right? And it is because we're also not given to thinking outside of the box. In Nigeria, there is a deep-rooted belief in the supremacy of litigation as a primary dispute resolution mechanism. This attitude is often exacerbated by skepticism regarding the efficiency and fairness of ADR process, particularly when they are not as widely understood or trusted as formal court procedure. Consequently, many Nigerians are unwilling to consider arbitration or ADR as a viable option for resolving their dispute, relying or especially referring to traditional litigation. How I must go to court. You know, somebody once made fun of us, those of us who are trial lawyers, that because of the wig and gown, the collar and the pin, rather than advise parties to settle, we would rather go to court. And I'll give you another example. And I'll be talking from practical perspective. I'll show you through. A woman came to me. She was owing a bank. And the bank was going to sell her house in the highbrow area of Ikoyi. And she now came to me that she wants to fight. So I said to her, you can't fight because there's a legal mortgage. And I know that all of us who are either body lawyers or lawyers, we know the legal implication when you have a legal mortgage. Do we agree? I didn't hear. Do we agree? All right. Like I said, I want to make it interactive and a bit more interesting. So she said to me that she wants to fight the bank. She didn't agree. She left me and went to meet another lawyer, and she said she needed a lawyer who will handle the case in court. So you see the problem being that sometimes litigants will also come and encourage lawyers to go to court on their behalf to keep a case in court. So I said to her, Madam, the lawyer who has advised you is only postponing doomsday. See that property of yours, not only will the bank take it over, the bank will sell it. The worst you can do is perhaps sue the bank for selling your property at an undervalue. But as far as the law is concerned, the bank is the owner of this asset. So you see, in some instances, individuals can also encourage litigation. Individuals who have this mindset that litigation is the fastest way to seeking redress will encourage their lawyers to go the litigation route and not open up themselves for those alternatives that are in place. Conciliation is also a process beyond arbitration. So ADR has several components. The most important thing in ADR is for parties to talk. Now, if you want to thrive, one, ensure that your reputation stands. You cannot participate in arbitral hearing or proceeding if you're a person of questionable character. Two, your learning curve must also be rich in terms of your knowledge of the field, your knowledge of law. Okay, so arbitration is a standardized training and considered accreditation for ADR practitioners in Nigeria, which further exacerbates this problem. Many individuals who offer ADR services may not possess the necessary skill or experience, leading to concerns about the quality and integrity of the process. As a result, businesses and individuals may be hesitant to rely on ADR, fearing that the lack of qualified professionals could undermine the fairness and effectiveness of the proceeding. The lack of awareness and misconception of ADR is also a problem. Oftentimes, we also need to create an awareness for people to also know. A critical issue preventing the widespread adoption of ADR in Nigeria is a lack of awareness and misconception about ADR. Businesses are not fully aware of this and potential of ADR. Are you aware that today, even employment contracts now have arbitration clauses being inserted so that you're doing away with litigation? Some of us will have heard of this case of Bernard Longe and First Bank of Nigeria. He worked as MD. He was removed unceremoniously. He went to court. It took him plus or minus about maybe 15 years from the High Court, Court of Appeal to Supreme Court. Finally, Court of Appeal determined the case and decided that he was unlawfully and wrongly removed. And then at the end of the day, all that he was entitled to as MD of First Bank, the court ordered that everything be paid back to him. So he became over ₦1 billion richer on account of the pronouncement of the court. But if they had inserted a clause in the agreement, and that's basically what we do now, encouraging companies, even in your contract of employment, in contract that you entered into, even in lease agreement, insert that arbitration clause and do it in such a way that it becomes your first option. It's only when that fails you then seek other alternative. Litigation should be the last resort. Because of one, the cost, and two, it's also burdensome. It's time wasting. As a trial lawyer, I can say this to you. Do I enjoy litigation? Yes, I have a passion for it. If you wake me up any minute, if I don't go to court at least 3 or 4 times in a week, I'm not myself. But when it comes to issues like this, it makes it easier for you to sit down and simply say, look, the client interest is paramount and it has nothing to do with you. But many of us are driven by money. And because we're driven by money, we do not advise our clients that, look, go the arbitration route and not litigation. Because with litigation, you make a lot more money than arbitration. Am I making sense? You make a lot more money. So we look for, instead of going the fastest and the quickest route, we'll rather take the shortcut. Judicial interference in ADR processing. Despite the modern legal framework, strong institutional support for ADR, judicial interference remains a challenge in Nigeria. In some cases, Nigerian courts have shown a tendency to intervene in arbitration or mediation proceedings, either by reviewing the merits of the dispute or by setting aside arbitral awards on procedural grounds. While courts are generally expected to refrain from intervening in ADR processes, Judicial intervention can undermine the effectiveness of ADR by creating uncertainty and delays. As I wind down, this problem is particularly pronounced in cases where the arbitration process involves public policy consideration. If one party seeks to challenge the arbitration on the grounds of fairness or procedural irregularity, judicial interference can lead to delays in enforcement and cause parties to reconsider ADR as a dispute resolution option, especially when compared to the relative finality of court judgment. This issue underscores the importance of strengthening judicial respect for arbitration and mediation decisions, ensuring that Nigerian courts uphold the finality of ADR awards. Now, the need for institutional support and public awareness has also come to our attention. To overcome these challenges, it is crucial that institutional support for ADR in Nigeria is strengthened. This includes expansion of ADR services to more regions of the country, particularly in under-reserved areas. Further efforts must be made to ensure that institutions involved in ADR, such as the Nigerian Arbitration and Mediation Center, Lagos Court of Arbitration, and the Nigerian Institute of Chartered Mediators and Conciliators, are better equipped and resourced to support a wider range of ADR. Now, government sets up a lot of these institutions, and they are underfunded because even the government itself does not even believe in ADR. In addition to expanding access to ADR services, there is a pressing need for public awareness campaigns aimed at educating Nigerians about the benefits of ADR. This campaign should address common misconceptions, promote the advantages of ADR in resolving commercial and personal disputes, and highlight its effectiveness in comparison to litigation. Business owners, legal professionals, and general public need to be better informed about the potential benefits of ADR, especially in terms of cost, time, and confidentiality. Furthermore, capacity building programs should be established to train more professionals in arbitration and mediation. This will help to bridge the skill gap and ensure that there is a sufficient number of qualified and experienced ADR practitioners in Nigeria. By investing in both institutional infrastructure and public education, Nigeria can enhance ADR framework and make this mechanism more accessible. You don't have to graduate first. And we must also understand this. ADR is not confined only to lawyers. You have non-lawyers who are also ADR practitioners, and I can name quite a number of them. You don't have to be a lawyer, but the key thing is you must have passion to resolve this dispute. The role of ADR in resolving disputes in areas of private law, arbitration and alternative dispute ADR mechanism play a central role in resolving disputes across various areas of private law. This mechanism, due to their flexibility, confidentiality, and efficiency, offer viable alternatives to litigation, especially in areas where parties seek amicable resolution without adversarial nature of court proceedings. Below, we explore how ADR is utilized in different domains of private law, including contract law, family law, tort law, business law, and consumer law. Imagine taking your landlord to court. Reflect on that for a while. But if you take your landlord to arbitral hearing, you will still remain as friends. Like oftentimes they say, once you sue your landlord, you're already out of the house. How dare you sue your landlord? So the landlord will now be saying that you have taken me to court, you have become my enemy. But if you take your landlord, for instance, to arbitration, you can talk, you can judge us. It's a more friendly, more relaxed environment for interface, for judge. So there's a need for parties to sit down, discuss. It's a win-win. It's not a winner and a loser thing. It's give and take. You sit down and you discuss. But you can't have that in arbitration. Once a judge steps in to hear the matter, one party will be agreed when the pronouncement is made. Unlike in arbitration, you're given an opportunity. And oftentimes when we go for arbitral meetings, the first thing they say to us is, lawyers don't speak. Obasanjo said, when lawyers are involved in any dispute, they compound the problem rather than resolve it. So they don't allow us to speak. So we just sit down to observe. When the parties are finished discussing, we can then now come in to guide them in terms of what the law is, but not to create a conflict that is not there in the first place. If you have to resolve disputes between parties, there's a need to have a friendly and conducive environment or atmosphere for the parties to face themselves and discuss. After all, when they were going into the party, so into the arrangement, into the contract, you are not with them. So you must allow them to discuss. You must allow them to open up themselves and agree. Contract law, the role of ADR in resolving commercial contract disputes is also addressed. Many commercial contracts, especially those in industries like the energy sector, Telecommunication and Finance now contain mandatory arbitration clauses which parties are required to also acknowledge in terms of resolving disputes that will arise instead of going to litigation. This is particularly useful in complex contract disputes as arbitration offers specialized expertise in areas such as construction, intellectual property, and international trade. I will also encourage all of us that are here, take interest in arbitration as opposed to litigation, but do not exclude litigation. A man once said to a friend of his who came to visit him with another friend, he introduced his friend as a lawyer, and he asked him, "Sir, do you go to court?" And he said, "No, I don't go to court." He said, "Then you're not a lawyer." Forgetting the fact that you don't have to be a court or a litigator to qualify as a lawyer. We're referred to as barristers and solicitors. So if you choose to be a solicitor, are you aware that some of the richest lawyers that we have in this country are actually trial lawyers, litigators? And I can say this to you off the cuff. Chief Affair Babalola is one of the richest lawyers we have in this country. Chief Wode Olanikan is one of the richest lawyers we have in this country. But they are trial lawyers. They also do arbitration. But the bulk of their money is from trial, is from trials. It's from litigation. And there are quite a number of them. As you have commercial lawyers, you also have litigators. The late Bankole Aluko SAS was one of the finest advocates that this country has produced. And today, his law firm is still standing. A law firm that can boast of nothing less than 5 senior advocates. Nothing less. After about the last office today can boast of nothing less than about either 5 or 6. There's hardly a lawyer that is a notable lawyer in Ibadan that didn't go through Affair Babalola, and they were not really doing commercial practice, 100% litigation. But the era has come, the world is changing. We're moving at a very fast pace. If you do not embrace arbitration or ADR to resolve the dispute, the world will leave you behind. There's hardly a document that you see now that you not see that clause, the arbitration clause. Hardly. And it was because of our own attitude. The world left us behind. But we have to catch up with them. Earlier I said all maritime agreements some years ago didn't have arbitration clauses as far as Nigeria was concerned. But because it was now being abused, it started inserting. Now, when is the sitting of the arbitral panel? In the past, it used to be Nigeria. Now they're more comfortable taking it to the UK. Now, imagine the financial burden that is now being placed on the clients, on those who have signed the agreement. Family law also has arbitration clauses. If you want to resolve disputes, oftentimes we say that when you have matrimonial property, some of us will understand this as we go through all of this, that matrimonial property is a property that the husband and wife have been living together. So whenever a dispute arises, particularly as regards divorce, you have to sit down and discuss how you share your assets. Oftentimes we say, and I'm not encouraging divorce, but it is a reality. You must sit down and discuss how the property will be shared. In Lagos, it's now 60-40. 60 to the man, 40 to the wife. It's no longer. So matrimonial assets will also be shared. And you must have an arbitration clause in the agreement of the parties. What some couple do is that they set up a company and ensure that all the assets that they have as husband and wife are managed by the company, and both of them become directors of the company, and there's a clause there. Whenever there's a disagreement between them, they must have recourse to arbitration and not litigation. So you don't go and wash your dirty linen in public. If we follow some of these clauses, some of the things that we read about in a divorce proceeding will not even arise. Sometimes divorce proceeding can be messy and dirty because one party feels aggrieved that I have labored with you, I've worked with you, and then you want to walk away with all of this. It's not going to happen. So what do? They let out everything out of the bag. There's also AGR in resolving issues of negligence and liability claims in tort. This is also something that we must also embrace. Mediation in tort cases allows parties to discuss their grievances, reach a settlement, and agree on compensation or other remedies without resorting to a court trial. Arbitration is also used in certain tort cases, particularly when the issue at stake are highly technical and require expert knowledge, such as medical negligence or industrial accident. The ability to choose an arbitrator with the requisite expertise ensures that the dispute is resolved by someone with a deep understanding of subject matter, leading to a more informed and fair outcome. Moreover, ADR can provide a quicker and more cost-effective resolution to tort disputes, benefiting both claimants and defendants by reducing the time and the financial resource spent on litigation. AGR is also notable in business law in relation to shareholders, employment issues, etc. AGR mechanisms have become increasingly integral in resolving corporate and business disputes. Business law encompasses a wide range of issues from shareholders dispute, employment, conflicts, and intellectual property issues. AGR is particularly useful in these areas due to the complex, high-stake nature of many corporate disputes. In shareholders dispute, arbitration is often the preferred method of resolving those issues because it provides a neutral platform for resolving disagreement between business partners or shareholders. Shareholders' agreement may contain provisions mandating arbitration to resolve conflict related to the governance of the company, dividend distribution, or corporate acquisition. Arbitration offers a fast. So right now, what we are also doing is the memorandum and article of association of the company must also have an AGR clause to guide shareholders, to guide subscribers, to guide the directors, the 4 directors of the company, that whenever an issue arises, your first point will be to go for AGR and not to go to court. Arbitration plays a vital role in resolving disputes in construction and finance sectors, where contracts often include arbitration clauses to settle disagreement over contract breaches, project delays, or payment issues. Last but not the least is the consumer law. And I'm happy that today Nigeria is also doing very well, and even because in the consumer protection law that we have and the consumer protection right. Consumer law is an area where AGR has made its right, particularly in resolving disputes between consumers and businesses or business owners. Consumer protection laws are designed to safeguard consumers against unfair practices, and AGR provides a more accessible and less formal avenue for resolving disputes without resorting to lengthy and expensive litigation. Now, before I draw the curtain on this, there's something that came to my mind. In Nigeria, when you buy a product and the product is defective and you return it to the person from whom you bought, what is their usual response? They won't accept it from you. Am I correct? Are you here? They won't accept it from you. Why would they accept it from you? Why would they accept it from you? Sometimes they say to you, once you walk out of the shop, it's no longer theirs. If you bring it back, what is the guarantee? That it is a product that you bought from them that you're returning to them. When my late father died, and being the only boy, I was mandated to be responsible for the casket. So I went to pay for the casket. And along the line, my uncle said, no. You go and take your money back. We put money together and we have bought the casket. Till today, as I speak, that money was never refunded to me. When I went back to them, they said, yeah, we'll take the casket. Whenever we sell it, you can come and take your money back. Till today, as I speak, the money was not refunded to me. Why is that so? Why can't we take a product back when we discover that it is defective? Do you know that in other civilized crime, that is a potential claim by me against the company that sold the casket? Is it because as a people we're distrust? We don't trust ourselves. The late Justice Keshin thing, when 7 of us doing the probe, how they stood before him. Some of us will have, I know that all of us will know the case of Donovan and CBC. Have I making sense? Right? Now, is it possible for a Nigerian finding a sediment in a drink, bought with your money, and you get hysterical? Is it possible? We're quiet. Law students, is it possible? Is it possible to be hysterical when you buy a substance and you find a foreign element in that substance, a decomposing snail or a fingernail inside that drink? Is it possible to get hysterical? You know what it means to get hysterical? All right? Is it possible? Some of you are saying yes. So now, those who are saying yes, let me see your hand up. Those who are saying yes. You know that you can get hysterical when you find such things in the substance. Let me see your hand up. You're saying yes. Those who are saying no, let me see your hand. Only few are saying yes. Can I ask you, where were you born? Ibadan. Now, what do your parents do? Your mom is a lecturer. Your dad is what? An advertiser. So your parents are enlightened and educated. Okay, yes, thank you. So that gives you an idea. Yes, you do. I hope you didn't say yes because of her. Okay, yes. Your mom is what? A lecturer. Security. A nurse. Ah. Okay, your mom is a nurse. Yes. What does your dad do? A legal practitioner. Okay, so your parents are out there enlightened and educated. So that's why you said it's possible to be hysterical. Did you also have your hand up? Who else? Okay, yes, there's a man there. Yes. Yes, I saw your hand up. That it's possible to get hysterical when you find a foreign element in a drink that you bought. Yes. It's possible. Okay, why? Okay, where were you raised? In Oyo State. What do your parents do? Are they still around? You know why I'm asking this question? Right? Please sit down. You know why I'm asking this question? Because by our nature, by the way we are wired, and by our background, and our parental influence will have impact on us in terms of the way we respond to things like that. And because we learn from them. I've been in a pub where somebody opened a drink and he was drinking his lager, his beer, and a fly flew into the beer. He brought out the fly from the beer, kissed it, and threw it away. Am I making sense? Somebody said yes. You know why that is so? Because that's who we are. But someone of color, other than our own color, from a developed environment, where things like that are not a common sight, right? We react, say, yeah. All right? But we will say, yeah. We will say, yeah, because we're not wired to behave in that manner. So Kesiki said, the reason why Donohu and CBC was decided in the way it was decided was because it is a system that recognizes how the average person in that society will respond when you cite such things. And that's the basis of thought. It's a common thing. How will the average Nigerian react when you buy a drink and you open it and you find some foreign element inside it? Either a decomposing snail. Kasiti said the people who came to court, because they didn't win the trouble, decided to sue 7-Up. Now what is the guarantee that you didn't open it to put a foreign element inside it? Because that's the mindset. So for us to have cases that will not go to court and be open for engagement, it's time for us to now begin to promote alternative dispute resolution mechanisms instead of going to court, so that you don't get to court and make a fool of yourself. So the time has come for us to sit down and to say, oh, when I open it, sometimes you ask the question, who was there when you opened it? When did you buy it? Who sold it to you? Did you tell the person when you bought it that this is what you witnessed? How did you respond? Did you take yourself to God? There are those who fall sick in the developed society on account of their exhibition to things like this. But not here. We move on. The general attitude is, if I can't change it, why will I even go to court? We don't even have confidence in our court system in terms of what will come out. A woman came to me once and she said, a doctor, this is a case for medical negligence. Now, ordinarily, she was going to court for. She had paid money for them to carry out surgery on her, on fibroid. They cut her open only to discover that she didn't have fibroid. So they sewed her up and cut her appendix. And I said, you mean you didn't go to court for? She said, no, I thank God that I survived. But that's the general attitude that we have. Oh, I thank God that I survived. It would have been worse. So if we must move forward as a people and as a nation, we must take advantages of AGR mechanisms that we have in place, other than litigation. Conclusion, as Nigeria continues to integrate into the global economy, the importance of effective and efficient dispute resolution mechanisms cannot be overstated. The role of alternative dispute resolution, especially arbitration and mediation, has become increasingly vital in resolving commercial disputes in a manner that is both timely and cost-effective. AGR offers a number of advantages over traditional court litigation, such as confidentiality, flexibility, and the potential for preserving business relationships, all of which are particularly significant in a globalized commercial environment. In light of the Arbitration and Mediation Act of 2023, which represents a serious step towards aligning Nigeria's legal framework with international standards, the country is well positioned to harness the full potential of ADR. However, despite this program or this progress that we have made so far, there still remains challenges such as accessibility, awareness, and enforcement of ADR decisions, the limited liability of qualified mediators and arbitrators, judicial interference, and institutional barriers still hinder the widespread adoption of ADR, particularly in smaller businesses and local disputes. Moreover, while Nigeria has made substantial strides in recognizing the importance of ADR, there is still a need for continued reform and development in this area. The establishment of more ADR institutions, increased training for arbitrators and mediators, and public awareness campaign will be key in promoting the use of ADR sectors in relation to private law. These measures will only help businesses and individuals resolve disputes more efficiently, but will also contribute to a more business-friendly legal environment. The role of ADR in Nigeria's private law system is poised to expand as globalization increases. The complexity of commercial transactions. For Nigeria to maintain its competitiveness in the global economy, there is need to further encourage ADR mechanisms, streamline processes, and ensure enforceability of arbitral awards. By doing so, Nigeria can provide businesses and investors with a reliable, efficient, and fast system for resolving disputes, thereby strengthening its position as a global commercial hub. The continued development and reform of ADR mechanisms in Nigeria are crucial for the country's growth in the global economy. The evolving landscape of international trade and increasing reliance on ADR as a dispute resolution tool provide a clear indication that the Nigerian legal system must adapt to meet these challenges. With the right reforms, Nigeria has the potential to become a leading jurisdiction for ADR in Africa. We're already doing that in terms of our size. Nigeria is the most populous black nation on earth. It is an area that is yet to be tapped into. And it's because we're actually not investing in that area. We're not investing in our population. We're not investing in education. We're not investing in academic. We're not investing in all of these issues. If we're able to do all of this, there will also be will attract foreign direct investment in monumental and humongous measure that we never thought of. How come foreigners are not really coming here? Because one, they're not certain of what the outcome will be if a matter goes to court. Two, they're not certain of what the outcome will be if they see alternative dispute resolution mechanism. Why? Because they see us as a people who are lacking in integrity, who are deficient of integrity, and who are also lacking in transparency and also in learning. And because of all of this, no foreigner will put his or her money in a system where you're not certain of what the outcome will be if you decide to go that route. And I conclude with this. A young man went to meet a sage many years ago, a very wise man. He said nobody has been able to fault this wise man. So this young man went to him to play some pranks on him, which is something we do now very regularly. The man had a bird in his hand, and he hid the bird behind him. And the young man looked straight into his eyes. And the man asked the young man, what are you up to? And the young man asked the man, what do you have in your hands? And the man said to the young man, what do you have in your hand? The young man said, I have a bird in my hand. Indeed, without even seeing, you already know what I have in my hand. You must be very smart. You probably operate the power of clairvoyance. Oh, very good. He said, okay, I will ask you this last question. This bird in your hand, is it alive or dead? What do you think the answer will be if you're the one? What do you think the answer will be? Can somebody be courageous enough to give? Yes. I thought I saw your hand up. What could the answer be? Yes, if you know it, please let me see your hand up. What would the answer be? Is it you? No, be courageous. Stand up and yes. Dead. That's the answer. Let's go. So she said, you agree with her? He said the answer is that the bird is dead. Yes. The answer is yes or no. You're also correct. Any other answer? Do you know what the man said? He said the answer is in your hands. If I say to you, the bird is dead, you will release it to fly. If I say to you, the bird is alive, you will squeeze the life out of it. So for you to be successful in this profession of art, The answer is your hand. Thanks for listening.
I will give a round of applause to Jessica. You will agree with me that this presentation was excellently delivered and warmly received. We thank you, sir, for taking time to go through this presentation. In an environment like this, sometimes to be able to still sustain the attention span of students, it is a reflection of the depth of that presentation. Thank you very much, sir. Because of the environment where we are, we would like to take 2 or 3 reactions or questions from the audience. 3 persons who would want to have questions. Okay, is worship? Could you please come? So you can scribble your question and send to me, or you come to the podium. Can you give a round of applause to the worship as it comes to this? So before the question and answer time, we would like to have the summary or remarks of the lecture recently delivered. Can you please welcome with me the Dean to do that? Thank you.
Thanks very much. I know the formal appreciation will be done at the end. Just to say a few words about the lecture and to thank the lecturer for taking us through 36 pages of the lecture without having to read all through. He was able to, in fact, there were times I had to be finding where he was here and there. But 1 or 2 things which I observed in the course of the lecture. One has to do with the case of P&ID, which I was surprised that, well, I know I discussed that case with students. I don't now know whether they are former students. You see, that's, it could have been either in criminal procedure at 500 level or law of evidence at 400 level. I'm not too sure now. But I know I discussed it with a group of students. And as Mr. QUAKERS said, it was a case that God bailed us out in Nigeria through the diligence of an English commercial court judge who just looked at the whole scenario. Oh, this is an arbitration matter. And did a bit of research to discover that the whole thing was a bubble, was a sham, including Nigerians who had compromised themselves. I think one of them is dead now, the woman legal advisor from Ministry of the NNPC or Ministry of Petroleum. And I know one of them is still alive. And it's a very treacherous matter. As he said, this country could have been a serious matter, serious financial mess had that been sustained. And also, I thank Mr. Quakers for highlighting the fact that arbitral awards or arbitration has become an area that's invaded by, well, inherent and pervasive corruption. That is the truth. Because for any group of arbitrators to have sat and given that award against Nigeria, in fact, that was the company, P&ID, was not a company in the real sense. I mean, everything they said they had done was a lie. It was floated for purpose of fleecing Nigeria. And thankfully, we have gotten over that now. In fact, in last week, it was the papers that by the Attorney General saying that we recovered not 200 million or something. So we thank God and a good judge. Good. What made me to remember this, or I wanted to talk about this, is that now that judge that sat in London, he said, wait a minute, for a company to have been awarded this amount of money, now that company should have been a company that everybody in the world will know of. And then he did a bit more, he looked more into the matter. And it's so painful because, as he said about litigation, it's time consuming and also has given us a bad name worldwide for being a jurisdiction that's defective in judicial integrity. One day, I was at BPP University in London. It's called University for the Professions. I was invited, actually, as DG of the law school for a day store. So I was there, and I went with a colleague of mine from the law school, head of the campus. And after touring and meeting with different groups, they asked us if we wanted to be at an afternoon lecture to see the postgraduate students in class. I said, oh, that would be nice. Now, I don't know whether it was by design or by accident, but guess what? The class they took us to was actually discussing Nigeria. And as we were entering the class, it was the picture of the former governor of Bayelsa. No, where was the Boris governor? Okay, Delta. No, it was Boris' picture in prison uniform that they were discussing. That was what they were discussing that afternoon. And it was so sad. Can you imagine, after feeling on top of the world, we had gone out to one of the best restaurants in London for lunch. He took us there, only to come and see a man who had been governor in my country being the object of discussion of the afternoon lecture. Of course, I just prayed that time will go fast enough so that we could leave that lecture room. Now, that is not, it's not the funny aspect I'm talking about. But don't forget, there was a judge of the Federal High Court in Asaba that exonerated Ibori of over 60 counts, if I remember, brought against him by EFCC. But this same man, after he was apprehended in Dubai and taken to the UK, was confessing like a witch to everything he had said he never did. And that was why he was jailed in England. So, sadly for us, litigation, which, as I said at the beginning, was the mainstay of legal practice when we
Let's lecturer and wife. Thank you, Lord, for blessings also granted on every activities. Yes. Thank you for our team. Thank you for our vice chancellor. Thank you for the deputy vice chancellor represented here. Thank you, Lord, for so much we have learned from today's lecture. It is of great utility and value. I pray that the knowledge acquired from this lecture will be of practical usefulness in real life situations and professional practice to our students and colleagues in the mighty name of Jesus Christ. Lord, as we thank you for the success of this faculty lecture, we pray, oh Lord, that we make our faculty to attain greater heights in the name of the Lord Jesus Christ. One of your wisdom and strength, grant our team, to all teaching and non-teaching staff, to our students and colleagues, Lord, continue to keep and preserve us and build this faculty to be one of the best in the community in the mighty name of Jesus Christ. Holy Father, as we depart now, I pray, Lord, that your presence will be with us. Pray, Lord, for journey blessings to our guest lecturer and wife. They will return safely. Your word says, "Give us prepared for battle the cities of the Lord." Grant them safety of the way as they travel back in the mighty name of Jesus Christ. May the blood of Jesus Christ cover each and every one that has come on this petition. As we depart in your presence, only us, O Lord. Till we have another faculty lecture, we pray that you will keep and preserve us and bless all our intellectual all other activities in the name of the Lord Jesus Christ. Be that exalted, Father. In Jesus' name we are praying. Amen. We praise together in praise of our Lord Jesus Christ. In love of God. Fellowship of the Holy Spirit. Be with us now and forever. Amen.